Hey everybody, we'll let you all get settled in. Thanks for joining us for the webinar today. We're glad to have you all with us. We're going to go ahead and, Will's here already. Samihan, all the usuals are here. All right, cool. I'm going to try to push this out to Facebook as well. So let me see if I can pull that off. How are you doing today, Mackenzie?
I'm good. It's been a busy morning. How have you been?
Good. I had a lot of consults today, so that was sort of crazy. Nope, that's not what I want. Nope. Let's see if we can pull this off. It hasn't worked before, but we have a new webinar provider. Everyone, let us know how you're doing in the comments. Let us know where you're watching from. We always like to see where our friends are and what they're up to. So let me see if I can push this out to going live on Facebook. Use camera. Yep. Share my screen. Share. All right. Got my mic on. They're always, every time I do Facebook Live, they change it. People sort of chatting in the group.
Yeah, lots of questions.
Cool. Oh, that doesn't look good. Let's do this. This thing never works, man. Every single time they change it. Good job, Facebook. All right, we'll forget about that. We'll just focus on the people that are here with us, and thank you all for joining us. It's the 12th of January, 12th of May, 2020. Glad you all are here. Latest news in immigration is that the Trump administration has issued a proclamation that purports to, that claims or is trying to stop immigration to the United States, prohibiting the State Department from issuing visas to the parents of U.S. citizens, the spouses of green card holders, the children of green card holders, the brothers and sisters of U.S. citizens, a bunch of different employment categories, and diversity visa lottery winners. So that case has been challenged in court. We filed a lawsuit ourselves. We filed our reply brief yesterday, and we will argue that motion on Thursday. So on Thursday at 2 p.m. Eastern time, we'll be arguing the legality of President Trump's ban on all those categories of people that I just mentioned. It's estimated that the ban will affect 35,000 people a month. And so we think it's a really important case, and we're excited about it. So, all right, with that, the only other news I would say is that following on the heels of that, the government is the Trump administration is also expected to try to curtail H-1Bs to the United States. And so those are employment visas for people in specialty occupations. So I just made a video about that one. And we've been seeing a lot of interest in that because obviously a lot of people come to the United States to study and to work, and they're all under attack by the Trump administration. It's an election year. It goes to his base. It makes his base happy. So that's why he keeps doing it. And so it's going to take lawyers litigating it and challenging it. And that's why we did what we did and filed the lawsuit that we did. We're real proud of the brief that we filed. It's a real long shot to think that we're going to win, but we're hopeful. So if you have any good thoughts for us on Thursday around 1 o'clock, 1 o'clock Central Time, send them our way because we'll need them. All right, Mackenzie, what's up? You're muted.
filing an overseas CR1 visa I-130 application. When the petitioner is filling it out, do they need to include other household members that live there but have a separate income or salary?
Read it again.
So when the petitioner is filling out the I-130, do they need to include other household members that live there but have a separate income or salary?
Well, the I-130, I don't believe asks about the household members, but if it asks for household members, you have to list the household members. If you're talking about salary for purposes of the affidavit of support, that comes later. So the basic answer to the question is if they ask in the I-130 who lives in your house, you should list who lives in the house. You don't have to go beyond that or think beyond what the question is. And that's probably a good lesson, is that sometimes it's good just to answer the question and not think about it too much.
Mm-hmm. Okay. Jaya Kumar asks, is it okay to legally work after the I-94 expiration date for 240 days if we were able to apply for my H-1B extension prior to May 25th, 2020?
You're allowed and eligible as long as the case was filed on time. You can keep working. Yeah. Mm-hmm.
Okay. Amuj asks, I'm waiting for my naturalization interview, and during this time I got married. On the N400, I put my status as single. How can I change my status, or what should I do in the interview if I get this question?
So that's not a problem at all. Certainly nothing to worry about. I just did a video on this very question. Not about that edit or change, but the immigration interview, whether you're applying for citizenship or for a green card, those are always an opportunity to correct your application. So no one's going to think that you lied or were trying to trick them if you got married after you applied. It's just a matter of going to the interview and updating the officer. So what I like to do, what we do here in the office, is we submit something called an errata sheet, which is ERRATA. I'll write it here, ERR. And that's where you want to make any edits to your application. So you would put errata sheet on the top, and then you would list the question that was asked and the answer that's different now. So if, let's say, I don't know the number of the question, but let's say question 17B is, are you married or single? And you'd mark single. Then I would write out question 17B, and then I would write the answer, no, I'm not single. Or my marital status is married is probably what it would say. So you just want to update that so that you're as complete and thorough as possible. It's also going to make your interview go faster if you just hand them the corrections.
Okay. Adit says that he just got a denial on his I-130 and I-485 in April. 30 days have passed, but he's still preparing to file a new application. Is there any chance that deportation proceedings would start within the next few months if he doesn't hurry up and refile?
Yeah, so when your I-130, I mean, number one, I'd be interested to know why the 485 and the I-130 got denied. That's usually problematic. I will say that we've seen a big spike in I-130 denials. I-130s used to be much more simple and much cleaner and got approved much more often. So they're definitely denying I-130s at a higher rate. I haven't seen the statistics, but I would bet that whatever the rate was before, it's now twice as much. But in any event, you do raise a good point, and that is, in most situations, I would simply refile like you're going to, but I would refile like my pants were on fire. I wouldn't wait around. You never know when they're going to put you in removal. One trick or one thing that you probably want to think about is there's a 1-800 number. It's 1-800-898-7180. I had to punch it out on my keypad in my head. 1-800-898-7180. That's the EOIR phone line. And if I had a denied I-130 and a 485, I would call that number about every other day or every third day and type in my alien number to find out if I've been put in removal. If you get the I-130 on file, and you should get the I-130 on file as fast as you can, if you're in removal, you don't want to file your 485 with USCIS. So that's why you want to call that number, because you want to see if you're in removal. Because if you're in removal, you're going to actually apply for adjustment in court. So you're probably going to need some help with that. Probably not something you want to do on your own. But if you file the 485 with USCIS, they might just deny it. They might reject it. They might keep your money, and you might have to file a new one with the immigration court. So you need to be careful with that. But yeah, you want to get it on file as soon as possible. Nobody really knows what triggers ICE from coming out on a particular case on a particular day. I told someone the other day they might come for you tomorrow. They might come for you 6 months from now. You just never know.
Mhm. Okay. Samar says there's an alphabetic mistake of my surname on my high school certificate. Will it affect my CR1 visa interview in Pakistan?
No. Nobody's going to care.
Okay. Samihan asks, if a U.S. citizen parent sponsors an unmarried child's green card and the child comes to the U.S. and gets married to a U.S. citizen, can the now married child naturalize in 3 years?
Yes. Yeah, so that's a good question. So there's a general rule that says that if you get a green card, you have to wait 5 years to apply for citizenship. But if you're married for 3 years to a U.S. citizen, you can get your green card after 3 years. You don't have to wait the full 5 years if you're married to a U.S. citizen. And so this question comes up sometimes when people get their green cards through employment or like through a U.S. citizen parent. So the question is, on the day that you apply for citizenship, did you have a green card for 3 years? And were you a citizen, or were you a lawful permanent resident for 3 years? It does not ask, how did you become a lawful permanent resident? In other words, you don't have to have received the green card based on the 3-year marriage. You can get your green card on an independent basis as long as those two requirements are met, that you've been a green card holder for 3 years and that you've been married for 3 years. So sometimes, let's say you get your green card first and then you get married 6 months later, you'd want to make sure that you waited until 3 years and 6 months after you got your green card, or 3 years after both conditions were met, married and a lawful permanent resident.
Okay. Is it a wise idea to file for the I-765 6 months after filing for adjustment of status through marriage? Will that delay the adjustment of status case that is pending?
Well, first of all, you should always file your I-765 when you file your I-130 and 45. So there's really no reason not to. There's no filing fee. There's no extra cost. It's going to get you work authorization and a social security number faster that way. So there's really no reason to wait. But if you did not do that, if you, for whatever reason, did not file that at the time that you filed the 45, you should go ahead now and do that. It won't impact the processing of your green card. Those two things sort of go along separate tracks.
Okay. Shay Lee says he's adjusting his status through marriage to a U.S. citizen. In preparation for my interview, I was looking through my I-485 and I noticed that when they asked about unauthorized unemployment, I say yes. Oh, hold on. No. So he put no on the I-485 about unauthorized employment. If he says yes when they ask about it in the interview, what will happen? Will it delay my case?
So just like I said before, he should have an errata sheet ready to hand them before the interview even starts and say, hey, before we begin, I want to let you know that on question part 728, hello, that I made a mistake and that I marked no on that, but I should have marked yes. And here's where I worked, and have the address answer the question of where you worked. If you work without permission and you marry a U.S. citizen, that is forgiven. So you can still get your green card if you've worked without permission, if you're getting that green card based on marriage. Now, if they think you're lying about it, or if you lie about it, that's a whole other problem. So you want to make sure that you're out in front of it right away, where you give them the questions ahead of time and the corrected answers. So you want to make sure to correct that before your interview. You want to hand it to them and say, I made a mistake. I actually did work without permission. Here's where I worked. And if you got paid in cash, no one's really going to care as long as you're honest. So it's better to be honest, always.
Program, but he wants to know if you can and how to get off of Carp, off of the list.
So for those who don't know, the Carp is the Controlled Application Review and Resolution Program. It's a program that went into effect under President Bush 43. And it's a program that's designed to slow down immigration to the United States by people from predominantly Muslim countries. People have their cases in Carp and they think of their names being in Carp, there's really no way to get off the list. The only thing to do is to deal with them by suing them. So a case will get hung up by Carp, and the only way to fix that, to get that case moving again, is to sue them and to file a writ of mandamus and a claim under the Administrative Procedures Act, stating that the Immigration Service and the State Department are unlawfully withholding a decision in your case because of Carp. And they like having Carp, so they don't want a judge to strike down Carp. So the only way to fix it, if you're on Carp, is to sue.
Mahmoud says that he lost his job because of COVID-19, but now he's collecting unemployment, and he has a couple questions. Does unemployment benefits count as income for tax year 2020? Does it count towards meeting the financial requirements set by USCIS to sponsor his girlfriend for a K-1 visa?
He's probably going to need a co-sponsor whenever you start talking about unemployment. The question isn't whether those benefits count towards income, which I don't think that they do. But the bigger question is, if you're unemployed, you're going to need a co-sponsor. So he should be thinking about getting a co-sponsor sooner rather than later. It won't prevent him from being the sponsor, but he's most likely going to need a co-sponsor because he's not working. They ask for updated pay stubs on an employment letter when you get to that stage. So he's going to have a problem with that.
Okay, Olga says that she has an I-485 adjustment of status pending, but she wants to maintain her F1 status as a backup plan. What happens if I use my I-485 EAD card to work? Are there any implications to my F1 status?
Say that one more time.
Okay, so she has an I-485 adjustment of status pending.
Yeah.
But she wants to maintain her F1 status as a backup plan.
Yeah.
What happens if she uses, you got it?
Yeah, I got it. So sometimes, so in America, you can have immigrant intent and non-immigrant intent. So immigrant intent means I want to stay here. And non-immigrant intent means that I'm going to come and leave at the end of my visa. So when you're on an F1 student, that's a non-immigrant visa. So you're promising to the government that you're going to leave at the end of your studies when you graduate. So if you marry a U.S. citizen, like, is it Olga? Is that her name? That you're muted again. But like Olga, you're going to get a work card based off that new application. And Olga asks a very good question. If she works with that application, is she thereby violating her F1 status? The answer to that question is yes. So if it's important to Olga to maintain her student status, she's going to want to not work on that EAD. She's going to want to work only on campus according to the rules of the F1 student, which is 20 hours a week on campus. So if she's worried that the green card case might not go through and she wants to maintain her status, she should not use the EAD that she receives based on the marriage-based green card case for working, because that would be a violation of the F1.
Okay. Aiden says that his mom's I-130 was refused due to public charge at the embassy. She was asked to present her and her husband's employment verification and 2019 tax returns. Should she only send what they asked for, or should she send other stuff as proof?
Always only send what they asked for.
Okay.
I know Olga said it's a work green card, not a spouse-based green card. It doesn't matter, Olga, same rule. If you work off that EAD, no matter how you got it, that would be a violation of your F1. So sitting tight is probably a good idea.
Okay. Dev asks, is USCIS deliberately delaying the I-485 based on asylum?
Wait, before we get to that, I want to get back to Aiden's question. Aiden, I think I might have been a little too rushed on yours. I think on that kind of a question, when there's a question about whether mom's going to be a public charge, I would send more stuff. If you can show that you have a job lined up for her, or that she has skills, or that her English is strong, even though that's not a part of the old public charge analysis, anything else you can submit that would support your argument that she won't become a public charge would be helpful. So I would submit more, not less. Sorry about that.
Okay. So Dev asks if USCIS is deliberately delaying the I-485 based on asylum.
Yeah, if you look, I just did a video on this the other day. I don't know if they're deliberately delaying the case. So for those of you who don't know, if you receive asylum in the United States, either through the asylum office or through the immigration judge, 1 year later, you can apply for a green card. And so the asylum office historically has always been separate from USCIS. So they've been on a different computer system. They've been kept separately. And so if an immigration officer is trying to decide a green card case, they might need to go track down the asylum case. And I think that it's not as easy to get as you might think. And so we've been seeing a lot of delays on asylum cases. And I really think the real reason we've been seeing a lot of delays is because the president and the administration have wanted to reanalyze whether these people that got asylum should have gotten it in the first place. So they're using the opportunity of someone applying for a green card to go back and revisit the asylum case. I think that's especially true if the person received asylum under President Obama. And so they think that asylum was given out too easily. And so they're going back to look. And so I think in answer to your question, I do think they're purposely delaying them. I don't think it's in a particular case. I just think there's just much more scrutiny of whether or not to give a green card. In the old days, you would get your asylum, a year later you would apply for a green card and it would come in the mail. Now they're interviewing everybody. So there's definitely much more scrutiny of those cases going on.
Okay. Okay, Roma says, oh, sorry. So they have some questions related to the I-539 and its impact due to COVID. They had a biometric appointment that was scheduled for March 31st, but the office was closed. They got no notification on that matter. For how long can they stay in the U.S. without being considered unlawful until they get a biometric appointment?
Well, I think that the thing is extensions and changes of status, which is what the I-539 is all about, have been under attack for a long time. So in the old days, you were here, you wanted to stay a little bit longer, you filed an I-539, they receipted it, and then they might give it to you, they might not. They were a lot more giving of it than they are now. And now it's really hard to get an I-539 approved. Now, obviously we're in very unusual times, very strange times for immigrants who are stuck in the United States. I think that there will be some leeway, but what I've been telling people is, number one, you should be doing everything you can to get your biometrics done, to get the extension moving. You should do everything you can to get out of the country on time. If you can't get out of the country on time, you need to document every single effort you make to get out of the country on time, because if you ever need to apply for another visa, if you ever try to come back, you're going to want to show that you try to comply with the law. So if a year from now you just say, oh, I really tried to leave, but it didn't work out, that is fundamentally different than if you give them a stack of papers and say, on March 1st, I tried to rebook my flight in April. On April 3rd, I tried to rebook my flight in May. On May 3rd, I tried to get a ticket to go to Europe so that I could then get to Morocco or whatever. Like, you have to document everything that you did so that you can show that you tried to comply. I imagine that there'll be some kind of guidance from USCIS about what they want to do with people who overstayed because of the virus, but so far we haven't been seeing that. So I think you just have to stay tuned, but in the meantime, you need to do everything that you can to try to get your case moving.
Okay. Muj says that his wife lives overseas and he's thinking about naturalizing. Should he wait until he becomes a citizen to apply for her visa, or should he go ahead and do it with the green card? What do you recommend?
Well, a couple things. Number one is the processing time for this. So there are an unlimited number of green cards available for the spouses of U.S. citizens. There is a cap on the number of green cards available for the spouses of green card holders. So usually there's a delay and a wait. Usually you have to wait 2 years for the spouse of a green card holder to come. But I would go ahead and apply for the spouse because you want to get that priority date. And if you become a citizen, you can accelerate you can let USCIS know, hey, I've now become a citizen. This case should go faster. So I would go ahead and do both. I wouldn't wait for citizenship to take a year. So why wait a year? Why not get the case on file? If the numbers are current, you're good to go, except for the fact that Trump has now tried to stop those people from coming. They will still process your case. I would say go ahead and file the case for the spouse and apply for citizenship. And then if you get your citizenship, just notify USCIS or the State Department at the National Visa Center or the embassy, wherever your case is at that point that you've become a U.S. citizen.
Okay. Barbara says, I hold a J1 visa, but I was just accepted into a PhD program that will start in August. What should I do? Is there any possibility to enroll the program with a J visa?
You're going to have to check with your program to see if they'd be willing to give you a new DS 2019. You might have to leave the United States and try to get an F1. That can be sort of tricky. So it's all going to depend mostly on what your program and the school are willing to do for you.
Okay. Theyve asks, I'm a green card holder and my wife is in the US. Currently, we are living in different cities due to job requirements. He went to visit his country in early December and had a return ticket for early February. He canceled the return ticket and extended his leave, but then got stuck due to COVID-19. My 6 months get over in early June. If I can't get back to the US within 6 months, would there be any issues?
So yes, you need to get back as fast as you can. We've had people make it back. I would say that you have to try, and just like I said about people trying to demonstrate that they tried to leave the United States on time, you want to do the same thing. You want to show that you tried to get back on time. So I would be very worried about that, and I would do everything I can to get back.
Lorena asks, I want to know, is there any chance to stay in the US after I finish my LLM? If there is, which are the best ways?
Well, if you're getting an LLM, that means you're a law student, which means that you're probably on an F1 student visa. If you're on an F1 student visa, you would be eligible for 1 year of OPT. You should obtain OPT, file for OPT, work for a law firm, and do such a good job that they're willing to sponsor you for an H-1B.
Okay. Cersei said that he was scheduled for an interview in April at the embassy, but the interview was canceled. When do you think the embassy will start to work on rescheduling the interviews? And also, is there any chance to postpone the diversity visa lottery 2020 until October or November?
No. There's no possibility of that, and I don't know when the embassies are going to reopen. That's one of the things we're suing over. But the fiscal year runs for each year, and if you don't make it by, if you win the diversity visa and you don't get your visa and your green card by September 30th, then it's as if you weren't picked. So there's no way to cover that. Hey, I got one here from Karen. She said we skipped her question, so let me read it. Hello, I have a question. My brother came here in 2017. He got his green card with conditions. He forgot his green card expired back in July of 2019, so he filed for renewal on November 22nd. We did not know, however, that we're supposed to file I-751. Right. So now we don't know what to do because they denied his green card renewal. So I guess I have to file the I-751. Says, do you want to appeal? And if I do, I have to file a 290B. No, don't waste your time or money on the appeal. And just file the I-751. You probably need some help because things are getting a little complicated now. This would have been very easy to fix if you just filed the I-751. But the only thing you need to file now is an I-751, but you're going to have to prove that the marriage is still ongoing and still valid. So as long as it is, you should be able to get it approved. But the I-90 was not the right form, and don't waste your time with the 290B because you don't need it. All you need is a 751. We had a guy in the office who filed his I-751 8 years late, and it got approved. So they can approve them late. You probably need to give a good reason, and I guess if you're confused about which form it is, I guess that's a somewhat good reason. But don't waste your time with the appeal. Just file the 751.
Andy says that he's looking to file an OPT extension or an H-1B with an employer. What are your thoughts on what is possible in the upcoming non-immigrant executive order with respect to those visas?
So I don't know that President Trump can mess with people who are in the United States. I don't know if he can upset immigration law for people that are here. So you should do your STEM extension. You should apply for the H-1B. I don't think he's going to be able to cut off H-1Bs here in the United States. I think he's just going to be able to cut them off for people at the embassies, if he's able to at all. I think he'll try, but I don't think he'll be able to affect people that are here in the United States. He hasn't gone after green cards. He hasn't gone off US. He hasn't tried to overturn USCIS procedures. He's only been dealing with the State Department because there's a provision called Section 1182F of the INA that he believes gives him this huge expansive power and allows him to bar classes of aliens from entering the United States.
Derek says USCIS has approved the IR2 for a stepchild of a U.S. citizen. NBC just received the approval. Since the child's mothers can fill out the DS-260 and the D-5540, what name does she fill in on the signature line, hers or the child's?
Hers.
Any advice for filling out these forms for an 11-year-old?
Well, I mean, generally we don't give advice on how to fill out forms. We have people here who that's their job, is filling out forms. As thorough as you can and accurate as you
can. Okay. Olalikin says, with reference to several presidential proclamations suspending entry of immigrants, she realized that among the group of those in the exemption are those whose entry would be in the national interest of the United States. Could you please explain the kind of people who can be legally argued to be of national interest?
So national interest is a term of art in immigration. It means people that are doing stuff that advances the country's interest. If you're relying on that provision to get around the proclamations, I think you're going to lose. So I wouldn't put much stock in that. It's really what it is it's just a safety net or a way that the State Department can let people in if they want. But I don't think it's something that you can affirmatively apply for. I don't think it's anything you can rely on. I don't think it's anything that's make your case go any faster. So I wouldn't spend much time thinking about national interest as it relates to the proclamation.
Okay. Robert says that he is in the Air Force, his wife and stepchild from Ukraine, but he is an American citizen. They had a child in America, and then they went to Germany on Air Force orders. But USCIS revoked his wife's green card due to leaving the USA and reaffirmed it by claiming that there's no proof that they're in a bona fide marriage. We have filed a new I-751. Will the new immigration environment hinder this getting approved?
Hi, Robert. Thank you for your service in the Air Force. We appreciate you keeping our country safe. This is a jacked up case. This never should have got denied. I don't know what's going on. It sounds like a real problem. If she came with you on military orders, it seems pretty screwy that you had that case denied. It's hard for me to give advice over based on the information you gave us, but I think you might want to think about doing a consult or something because I think we can help you and get this approved. But as far as whether I think the immigration environment would hinder that, 751s when you're outside the United States are tricky. I think we need to talk about what are your long-term plans? How can we establish residency for her here in the United States, and why in the world, if you have a child, would they say that, oh, it's a stepson? It's interesting. I mean, you don't get many denials that say you aren't in a bona fide marriage. So I'd be interested to see all that. It sounds like something's wrong.
Ashraf asks, can I apply for an I-751 and apply for U.S. citizenship at the same time? If so, how is the physical presence counted?
They're wanting to know, can they apply for a 751 and naturalization at the same time?
Mm-hmm.
Okay, I'm going to assume what they mean is that can I file for naturalization while my 751 is pending? Because you file the 751 after 2 years of having your green card, you file for Nats a year after that. So I'm assuming that's what they mean. Yes, at first, so 751s used to take 2 or 3 months. And as soon as those started getting slowed down, we started filing naturalization cases right away. But it really does confuse USCIS when you do that. So we've been actually advising people, unless there's some compelling reason to try to get their citizenship sooner rather than later, we've been telling people to wait to file that N-400 until after they get the 751 approved. It's hard for me because I always want to get the immigration benefit as soon as possible. I always want to get the priority date as soon as possible. But technically you can. But what happens is when you show up, you'll get an interview notice either for the N-400 or the 751, not both. And you'll show up and they'll say, oh, I can't decide your N400 because your 751 hasn't been approved. Or I'm ready to do your 751. Where's your wife? But we can't do your NAP. So it really sort of, it's a screwed up system.
Mhm. Okay, this one was sent to me privately, so I'm not going to say the name. But he says, my spouse's ex has been harassing me. She called immigration and told them that I'm a criminal, I'm involved in human trafficking, etc. This is all a lie. Will or could this affect my upcoming case?
It might make for a more interesting interview. It might make it so that you get some more questions at your interview. If I were you, I would get documentation of the divorce for when you have the interview. If your wife can talk about how this person was abusive or mean or unstable, that would be good. If you can find any criminal records involving this person to bring to the interview. I think that it's certainly not going to mean that your case can't be approved, but it might make it a little harder to get it approved.
Mm-hmm. Okay, so Kay asks, I'm an F1 student. My wife is a US citizen. They've been working in different states due to work and have separate addresses that are used on the I-130. Now, since they're both working from home, his wife is flying down to visit him and staying there for 3 months. This is a temporary visit, but should she notify the change of address to USCIS?
Yeah, I would, and I would document whenever you're living apart from your spouse. You want to document all the time that you spent together. So, I would definitely update the address. It's always good to have both people on one address. You can explain what's going on at the interview, but for the most part, if you're living apart for business reasons, anything you can do to document why it is financially sound for you to live apart, all the efforts that you've made to be together, and all the time that you spent together, that's all good stuff.
Mm-hmm. Okay, Samihan asks, have you ever encountered a situation where USCIS just doesn't give you a receipt notice despite sending an application multiple times? Can USCIS ghost you?
Yeah, it's not so much ghosting, it's just that they lose stuff. So yes, the answer to that question is yes.
Okay. Robert says, thank you. He was convinced they were insane at USCIS. I think we got, for the most part, a lot of these questions. So here's another one.
Okay.
What can you do if ICE sits on an NTA and does not file it for years?
Say that again? If you're sitting on an NTA?
Yeah, what can you do if ICE sits on an NTA?
Well, it depends what you want to do. I mean, if you have some other kind of form of relief, I'm trying to get that other form of relief moving as fast as I can while they're sitting on the NTA. It depends what your overall strategy is. It's sort of hard to answer that in a vacuum. But sometimes, a lot of times, especially with Trump in office, if ICE is sitting on your NTA, that's a good thing, not a bad thing.
Okay. Mahmood asks, can you please expand on what you were saying about how unemployment affects your income on the applications?
I don't believe unemployment. I don't believe unemployment. The money that you get from the government counts towards your income. It's income replacement, so that's not going to help you on the affidavit of support. I also think that if you are a U.S. citizen or a green card holder sponsoring a family member to come to the United States and you're the principal sponsor and you are unemployment, you are going to need a co-sponsor. You will no longer be eligible, even if you made $150,000 last year. If you're not currently employed at the time of the interview, you're going to need a co-sponsor.
Mm-hmm.
Shaylee, yes, you should file a police report and bring it with you. Mm-hmm.
Okay. Y says, is there a way we can expedite our K-1 visa interview to meet my fiance who is a widower? He is alone at the time for health reasons, but I really need to be with him. My interview was scheduled for today, but has been canceled by the embassy. So is there a way that they can expedite their K-1 visa interview?
No.
Okay. Barbara, we answered that question about enrolling with the PhD program with the J visa.
Wait, she's saying we didn't. But is there any possibility to enroll the PhD with J1 if I'm not able to go back to my home country to get F1 right now? Again, that's only if the program will give you a DS 2019. If they won't give you a DS 2019, you're screwed.
Okay. Is immigration creating any problems for green card holders in general, staying in a foreign country for more than 6 months and not returning due to COVID-19 situation.
As I mentioned, we don't know yet. We haven't seen what they're going to do. We don't know what they're going to do. So I think that we'll just have to wait and see. I think there'll be some guidance, but so far that there hasn't. So I think we're good, huh?
Yeah, that looks like a lot of the questions. Smihan asks, you want to keep going or no?
We can do this one and then I'll end. So
Okay.
if you've been outside the United States for a long time and you want to apply for citizenship, you have to wait 4 years and 1 day from the return to the United States after that long trip abroad. That's how you reestablish your residency. And Smihan asks, are those cases scrutinized extra heavily? The answer to that question is yes. Anytime they think they can deny you, so if you don't make those 4 years in 1 day, they're going to deny you. All right, everybody. Well, thanks for joining us. We're glad that you were here. We'll do this again in a couple of weeks. Next week, we'll do our visa delay webinar. If you have any questions in the meantime, email us. We're glad you all were here, and we wish you the best of luck. Thanks, everybody. Yeah, Jim is tired. It's Ramadan. I'm fasting. I'm tired. All right. Thanks, guys. We'll see you later.